5 seconds to go. Start. There is no limitation on the nature of order or decision to be appealed against, as in this case, the right of appeal cannot be further curtailed by this court on the basis of an interpretative exercise. Stop para. Under section 35 of FEMA, the legislature has conferred a right of appeal to a person aggrieved from any order or decision of the appellate tribunal. Stop. Of course, such appeal will have to be on a question of law. Stop. In this context, the word any would mean all. Stop. Para. In the instant case also, when a right is conferred on a person aggrieved to file appeal from any order or decision of the tribunal, there is no reason, in the absence of a contrary statutory intent, to give it a restricted meaning. Stop. Therefore, in our judgment in section 35 of FEMA, any order or decision of the appellate tribunal would mean all decisions or orders of the appellate tribunal, and all such decisions or orders are, subject to limitation, appealable to the High Court on a question of law. Stop. Para. While holding that the word any in the context would mean all, this court observed that a right of appeal is always conferred by a statute. Stop. It has been held that, while conferring such right, a statute may impose restrictions, like limitation or pre-deposit of penalty, or it may limit the area of appeal to questions of law or sometime to substantial questions of law. Stop. It has been held that whenever such limitations are imposed, they are to be strictly followed. Stop. It has been held that in a case where there is no limitation, the right of appeal cannot be curtailed by this court on the basis of an interpretative exercise. Stop. Para. Shri P. Chidambaram, learned senior counsel, relied on the judgment of this court in the case of Union of India versus A.B. Shah and others supra. Stop. In the said case, the High Court was considering an appeal preferred by the Union of India wherein it had challenged the acquittal of the accused by the learned trial court, which was conferred in appeal by the High Court. Stop. The learned trial court and the High Court had held that the complaint filed was beyond limitation. Stop. This court reversed the judgments of the learned trial court and the High Court. Stop. This court, while interpreting the expression at any time, observed thus, para. If we look into conditions 3 and 6 with the object and purpose of the act in mind, it has to be held that these conditions are not only relatable to what was required at the commencement of depillering process, but the unstowing for the required length must exist always. Stop. The expression at any time finding place in condition 6 has to mean, in the context in which it has been used, at any point of time, the effect of which is that the required length must be maintained all the time. Stop. The accomplishment of object of the act, one of which is safety in the mines, requires taking of such a view, especially in the backdrop of repeated mine disasters which have been taking, off and on, heavy toll of lives of the miners. Stop. It may be pointed out that the word any has a diversity of meaning, and in Black's Law Dictionary it has been stated that this word may be employed to indicate all or every, and its meaning will depend upon the context and subject matter of the statute. Stop.